Nicole versus Drew. Now, of course, then you have a fiance. You have a fiance. Hey, Judge. Hi, everyone.
I was in here probably about 2 months ago, but
Oh, yeah.
just in case.
Good to see you.
Me too. Yeah, so we had some problems then too, but it's every, like we say, anytime we have there's always somewhere there's an issue. It's just technology. Yeah, it's definitely a lot of people on. There's a lot of people outside too. That's right. Wondering if they're planning on putting anyone on the stand. I should jump on.
It's
Device
live.
up there.
Probably it's
Okay.
not.
Yeah, I've got one ready. I'll go ahead and set it up
Okay.
there.
And I
Thank
think
you.
we're live right
What's that?
now. We're live.
Oh, I need to.
add-on class. 137539. Security alarm checking courtroom 585 Alpha. Big crowd out there. Is it, you know, if it's a state or a superior? Superior. Okay.
Well, you want to sit in the very front or the back? The back, or the back, so you can observe. What are we saying? Yes. Yeah. I'm just not right at the end of the day.
Hello, everybody. Please take your phone, put your phone on silent or off. Not vibrate, silent or off. You have to use your phone, go ahead and step outside the courtroom. Only one is allowed inside the courtroom. You gotta get someone else to have a sack, please. Please go outside before you come inside. Yeah.
December here.
Which one is
I think you guys are better.
Okay. Hello. Hey, how are you? Good.
Yes.
Plenty of sound on this side.
person.
Yeah, okay.
You should be sitting down. Drew, which side are we sitting?
Oh, we're on this side. Nice to see you.
Thank you for getting here. John is in the room. She already knows. I didn't bring an
I'm sorry.
It is. Thank you for coming. There you go.
Because it's several people away, and I don't want to get caught up in it.
You go sit with more.
Your word.
Get an extra chair. Did you have access to everything? And the second thing is, I think there are going to be some kind of walk towards just any chair. Yeah. Okay, so I guess. And then let's see.
You can, use the front row of my attorneys. If you're in time, come up to the pretty far side. For those who just walk in, please make sure your sound not vibrant. Sound are off, not vibrant, sound are off. Trying on the way, and use phone and how to use the phone.
Surreal.
Sure, so you need access? Yes. It's under my stuff. Melinda? And you said Wilson? Who was the one who's?
Taylor Wilson.
Okay, I see. Yes.
I just couldn't let you
All rise, Spirit Court of Fulton County of Annapolis, second now accepted, the Honorable Judge Scott Franklin, before we come to order.
Thank you, everybody. Please be seated. All right, good afternoon. Thank you. First thing we ought to address is understand we have Ms. Johnson here as our court reporter. And let's just confirm who is going to be sharing, if there is going to be any sharing of the cost of takedown.
I would be sure. Take that cost.
Understood. And on behalf of the plaintiff, Mr. Beal, are you going to be arguing today?
Only part of it, Ms. Brown will be arguing, most of the contempt issue.
All right, and we're still dealing with our live stream here. I'm gonna make sure I'm not, get rid of any echoes. And on the defense, who's gonna be the arguing?
We're gonna be splitting tasks.
Okay,
Thank you, Judge.
all right. So I think the way we have it teed up, we have three things to get through. And two of those by way of motions filed over the weekend. I felt like just to kind of get things warmed up, one of those might be the best way to start, which was dealing with the sealing of the docket. And so why don't we start there? I believe that would probably just be argument to kick it off. And that'd be a good way to, well, then it's going to be an easy one, isn't it? All right, let's just to make sure that I'm not missing any of the background as I read it. And I read the prior judge, I think it was 2 judges ago, who was assigned to this case, just sua sponte decided without motion of either party to seal the docket. And it's been that way ever since.
Right.
And I'll make sure we'll go in order here. So let me start with the person who filed the motion, which would be the defense. So Mr. Reyes.
Yes, Your Honor. Back in 2020, years ago almost, Judge Constance Russell made
Whatever makes you more comfortable.
sealed the record in response to a motion to strike redundant, immaterial, impertinent, and scandalous language, where the remedy would have been to strike paragraphs 111 to 188 instead of sealing the record.
And that motion is still pending. We're still going to get to that at some point. Is that the case?
To seal the record?
No, the motion to strike. Is that still out there that we need to get to at some point?
The judge sua sponte sealed the record.
No, I understand that. But the original motion that prompted that was the motion to strike that you filed. Is that still unresolved?
Yes.
Okay, that's all. I just wanted to make sure. And so please continue. I'm just carrying on here.
Well, sealing the record didn't accomplish, I think, what the judge intended, because when she sealed the record, Mr. Wood's, the complaint filed against Mr. Wood was already in the public domain and had been used as a sword against him to attack him. And then when this record is sealed, it's his responses to those attacks that are sealed because the complaint was already out there. So he's unable to tell his side of the story. And that's why, and again, the remedy for a motion to strike is not to seal the record. The judge didn't have that authority, if I may, to seal the record based on a motion to strike impertinent language. She should have just stricken paragraphs 111 through 188. Without that language on the plaintiff's complaint, there would have been no need to utter any comments about what was stated in those 80 paragraphs that had nothing to do with the lawsuit, which is about a breach of contract and a fraudulent inducement. Whatever happened in a hotel elevator a year prior in Beverly Hills had nothing to do with a breach of contract and a fraudulent inducement that they pled in the complaint. It was only to hurt Mr. Wood's name, image, and reputation, and that's what they did. And yeah, we request that the court unseal the record.
Okay. All right. Mr. Beal.
Real briefly, Your Honor. Let me just set the record straight. They filed a motion to strike portions of the complaint. The judge has not ruled on that. We contend that there is no law to support that. The judge, sua sponte, as you suggested, sealed just the complaint, not the whole record. It was just the complaint. So we contacted the court and said, we have other filings. How do we do it under seal? And they said, it isn't going to be under seal. Only that original complaint is under seal. So we have since filed an amended complaint, done a bunch of other stuff.
Which is interesting. I think the order actually says you're directed to seal all filings. So if y'all are actually able to access all these filings, then something's up to the clerk.
Up to that point.
Right.
And so we contacted
Okay.
the law clerk and said, we want to continue this sealing as the judge ordered. And she said, no, it was only up to the date of that order, which didn't make a lot of sense, but she wanted to do it as a prophylactic measure and seemed fine with us and fine with the defendants. And so that's the way it has been for quite some time. If they want to unseal it, that's fine. We don't admit or accept any of the allegations in their motion. And I guess we should file a real brief 2-page response. But if they want to unseal it, that's fine. Most of the record is unsealed.
All right. So then as it comes to, let's see, defendant's motion filed May 27th to unseal the record, it being unopposed, that'll be granted. And Mr. Reyes, if you could get us just a brief proposed order on that, we'll get that signed and filed whenever you get it to us.
I'm not in town, in my town tomorrow.
Whenever you get it to us. Okay, let's get to the heart of the matter then. So where we are now is, I think I've reviewed all the briefs and the filings on this case, so I'm pretty familiar with the procedural posture, which is we have a complaint is filed. We have an interlocutory injunction entered by Judge Russell in December 2020. I believe the first motion for contempt is filed by the plaintiffs in May 2021. That's simply kept on hold without a hearing or really anything as the case made its way through the appellate process. We hear back from the Court of Appeals in February 2022, and then there is a renewed request and a supplemental essentially made by filing, or excuse me, by emailing to the court, kind of supplementing the motion for contempt just a few weeks ago. So to that end, let's get into that. So this being plaintiff's motion and it being an evidentiary hearing, I'll turn it over to you. I'll turn it over to the plaintiffs.
Thank you, Your Honor.
Excuse me, Judge. We filed a motion to dissolve the interlocutory injunction. You want to hear that after? Or?
So I do want to hear that. In my mind, it seems like much of what might come out in regards to what happened while the interlocutory injunction was in place would be relevant to that argument. And correct me if I'm wrong, if you have any other case law that suggests it, but even if we dissolve the injunction today, there would still be the fact that if their violations were proven before it was dissolved, those would still be actionable. Is that fair?
That's fair.
All right, so it seems like the order we should go is chronologically. Let's do that.
Good afternoon, Your Honor. Again, my name is Smiley Brown, along with my partner, Andrew Beal, Beal, Sutherland, Berlin, and Brown, who represent the plaintiffs in this action. And it seems like you are quite well versed with the procedural history related to the motions up to this point, so I'm not going to belabor that point. So I'm just going to go ahead and dive right in. Your Honor, despite the plaintiffs being awarded an interlocutory injunction way back in October of 2020 that enforced this non-disparagement provision in the settlement agreement, defendants have not only knowingly but willfully violated the order on too many occasions to even count. Defendant Wood has even went as far as admitting his willful violation in writing when he took to Telegram and stated, quote, "I'll take the chance of a judge putting me in jail for contempt," end quote. And another time he also said on Telegram, quote, "Even if they put me in jail or whatever they try to do to me for saying he broke the judge's order, I'll take my chances." So defendants have admitted in writing and in a video that they've posted, that defendant Wood has posted on his Telegram account, that he knows what he's doing. He knows there's an interlocutory injunction that's been awarded. He's knowingly violating it. He is flying in the face of this court's jurisdiction and the ability for the court to manage the case, and he's hindering justice. And so we're going to highlight some of defendant Wood's violations to the court today, but given the extreme pace and the nature of the continuous violations of the injunction order, if we were to sit here and go through every single one of them, we would be here well into the night, maybe tomorrow night. No, that's not what you want, neither do I. So we're just gonna highlight some of the most egregious violations for your honor. And so I'll get my paralegal, Michael Glossop. We have created a little PowerPoint to help streamline things for us. I believe it should be on his screen.
I can see it.
Okay.
Slideshow, you should. Perfect, thank you. This is the first time being back in person in a while with technology, so I appreciate
Welcome
your
back.
patience. You can go ahead and go to the next slide. So for us as the plaintiffs to prevail on this motion for contempt, Your Honor, we only have to establish two things. One, that there was a court order requiring the defendants to take some action or refrain from acting. And then second, that the defendants willfully failed to comply with this order. These are so easily checked off here that I mean, we could honestly stop the hearing right after in about 10 minutes. There was a court order. The interlocutory injunction was awarded in October of 2020. Defendants exercised their right to appeal numerous times. They went to the Georgia Court of Appeals. Then it got transferred to the Georgia Supreme Court. It got transferred back to the Georgia Court of Appeals. The Georgia Court of Appeals affirmed the injunction. Then it went up to the Georgia Supreme Court again. They denied cert, and then he even tried to do an untimely petition to the United States Supreme Court, which they decided they were not going to accept because it was untimely. There's an injunction order in place here. The case law is clear. We cannot even get to the merits of the injunction. Mr. Wood does not get to come in here and argue whether or not the injunction is valid or his constitutional right under the First Amendment, because the case law is clear, and this is enumerated in the Stardust case from the Georgia Court of Appeals, that on a contempt motion and in a contempt hearing, the injunction is determined valid They don't get to go and say it's unconstitutional, any of the merits of the underlying injunction, because he's already exhausted all of his appellate rights. And so there is a valid order here. So let's talk about what the interlocutory injunction actually says. As you alluded to, Your Honor, there was a prior judge, Judge Russell. She found specifically in the order several things that help guide us today in determining whether this was a willful violation or not. The court determined, one, that the parties executed a valid settlement agreement. And part of this settlement agreement stated that the defendants shall not disparage the plaintiffs. They have not only at that point disparaged the plaintiffs, but they stated in open court their intention to continue to do so, which was why they were inviting the injunctions in the first place. And because of that and the threat of irreparable harm to my clients who are attorneys, having thousands of people of the public, hundreds of thousands of people of the public told that they cannot be trusted, impacts their ability to practice law.
Thank you, Deputy.
Okay.
You'll notice you sound much more authoritative.
Honestly, I did not even realize it was not on. Thank you, Bailiff, for your help. Okay, so we go to the next slide. So that's basically a summary of what the interlocutory injunction enumerated as what the court's findings were. And specifically here, in the injunction order, what is most important for today's analysis is what the court found in the order as being disparaging on its face. So the court put the defendants on notice that saying statements that the plaintiffs, one, filed a frivolous lawsuit, two, for purposes of extorting the defendants, three, that they were seeking to be paid money that they did not earn, and four, that they were participating in a shakedown effort, were disparaging on its face. And so the defendants were on notice based on the court's order, and that is a direct quote from the court's interlocutory injunction, that those specific types of statements are considered disparaging based off what had occurred up until the injunction being awarded. So there are other statements the defendant would have said, countless, that are disparaging on their face as we contend, but in terms of willful and knowingly violating this order, the defendants were on notice that these types of comments were not okay. He has repeatedly said these types of comments over and over again, and just in direct disregard to this court's authority and the interlocutory injunction. The court also said that the defendants disparaged the plaintiffs by saying, quote, he attacked their characters, ethics, integrity, and professionalism, end quote. So those types of comments about the plaintiffs, defendants were already on notice that that was in violation of this court's injunction. So next slide, please. And as I alluded to earlier, the court even quoted the fact that having hundreds of thousands of members of the general public being told by a trusted source that the plaintiffs are engaged in criminal behavior and cannot be trusted will negatively impact their ability to engage in their chosen profession, end quote. As I stated earlier, the plaintiffs here are all attorneys, and having someone with such a huge Telegram following that is not a private page, this is a public page we're dealing with. You could pull it up right now, even though you're not a member of Telegram, presumably if you're not, anybody can access this at any time. And so the fact that anybody in the general public can see these statements, it is disparaging to my clients because it impacts their ability to practice law. And so this next slide is the direct statements of what the court ultimately determined was disparaging, that issuing, publishing, or making disparaging comments or statements, or disparaging comments about plaintiffs, whether orally in writing or through social media. This is where the court gave the defendants an exception. The defendants are allowed to provide truthful information about the plaintiffs within the confines of this lawsuit or any other state, federal, or local government investigation or proceeding. And the court has already determined in the injunction, which is not up for debate at this moment because it's already been appealed, that defendants are not allowed to go on Telegram just because this lawsuit is pending and disparage the plaintiffs. The judge specified that during means within this lawsuit while it's going on. So he cannot do that while this interlocutory injunction is pending. So I've already told the court how defendant Wood knowingly violated this court's order and even said that he'll take the chances of the judge throwing him in jail. So we'll go ahead and go to the next slide. So now we get to these types of knowing and willful violations that are already enumerated in the injunction. Defendants were on notice that saying things such as that the lawsuit that plaintiffs filed was frivolous, or that the claims or the allegations were frivolous, were disparaging on its face, because that's what the injunction order language says. Right now in the record, which consists of our motion for contempt with the affidavit submitted by plaintiff Nicole Wade, the supplemental motion for contempt with the affidavit submitted, a supplemental affidavit submitted by Nicole Wade, there are 28 violations of defendant Wood saying frivolous lawsuit, frivolous claims, all in relation to this lawsuit, which he already knew was against this court's order. Since then, there are an additional 21 such violations that are not in the record that we are happy to submit to the court. But I only got to June 16th, 2021 to March of 2023. So there's presumably more that is outside of that time period as well. So there are already 48 of these frivolous types of lawsuit allegations, disparaging comments that defendant Wood has made throughout the pendency of this interlocutory injunction. Here's just another example of defendant Wood stating things that are in the injunction order that he knows is considered disparaging. Again, frivolous fraud lawsuit. In an effort to extort money from me. He's already on notice that he can't call them extortionists or say that they tried to get money that they did not earn. All of these things, extortionist lawyers, he repeats that 3 times in this one statement from May 12th of 2021. Again, yet another example of willful violation of this court's order. Here's the next slide. So what kind of impact has this had on my clients? Just to give the court some flavor of what kind of reaction that they have received from defendants' massive Telegram following. Here's just some of the examples that they have received from at various times. This person says,
Your Honor, I object. This isn't a comment that I made. This is a comment that apparently somebody made or posted, and I'm not responsible for that.
All right.
Your Honor, it's
Objection.
submitted in our original brief and it's attached to the affidavit. And it goes to just showing this court that there is a real impact and why defendant Wood needs to be stopped and why we need not only to hold him in criminal contempt and have an order awarding damages, but we also need to deter future conduct so that these sorts of things don't happen again.
So I have reviewed the motion. I'm familiar with the material that you provided. I do think that what we're here for today is simply to see whether he violated the order or not. So I recognize that there are ancillary ripple effects from it, but I don't think that's really all that relevant to what we're doing here today. Was the order violated or wasn't it?
Yes, Your Honor. Okay, well, we'll move on. In the event that defendant Wood tries to argue that this has no impact, we put this in there because we were anticipating that's something he's raised in a motion before, that it did not actually impact my clients. If the judge would then like to hear about it, we can come back to it. Okay. So going in. It's either one or the other. I'm too loud or I'm too soft. So kind of going in order of some of the Telegram posts that have occurred, some of the ways that defendant Wood has disparaged the plaintiffs is that he has taken things from this litigation and shared them publicly, even though that again is in direct violation of this court's order. So in this March 24th, 2021 Telegram post, he posted a letter, which is a litigation hold letter to Brian Cave, the law firm. And that law firm, plaintiff Nicole Wade used to be a partner at. And so in this, he's saying, hey, Brian Cave, you need to make sure that you are holding all of your communications, those sorts of things. You need to preserve evidence related to plaintiff Wade. This is relevant because he goes on to attack plaintiff Wade's mental health and mental capacity in public statements and disparaging her. So we'll go to the next slide.
John,
I
again,
think we have another objection here. Mr. Wood.
I object. Posting a litigation hold letter does not disparage anybody. Now, if there's other statements about Nicole's mental health, I think we ought to see those and put them in context. But this is an example of where they're trying to add up a number to come up to 38 or 40 or whatever. And many of them, if not most of them, do not constitute disparagement.
All
So
right,
I
Mr.
object.
Wood. Well, as I take that to be more arguing the weight of the evidence, I think we would say that to your turn. We'll let them contend everything they think does violate it, and then we'll let you have the floor.
Thank you.
And we'll see in a future slide where he comes back and he talks about that direct post and a subpoena that he sent to Brian Cave about plaintiff Wade and her ability to falsely attack him and history of retaliation, but I digress. So in this March 24th, 2021 Telegram post, he is posting things that are in the context of this litigation. Actually, this one is outside of this litigation, by showing that he sent a response to the Tennessee bar related to defendant Wilson's application to practice in Tennessee. And what's interesting here is the first post had both screenshots, both the cover letter and this actual form that he sent to the Tennessee bar that says what his comments are related to defendant Wilson. That since has been taken down. And so here we have him saying that he's learned substantive information which requires a change in his responses concerning Mr. Wilson's character and fitness to practice law. So again, he's calling into question defendant Wilson's ability to practice law, casting him in a negative light in direct violation of this order. Oh, okay. So immediately prior to this post in May of 2021, he calls all three plaintiffs out by name. And subsequently, this message followed within minutes after, and he says, wait until these incompetent lawyers examine me. So again, he's casting them in a negative light, saying that they're incompetent lawyer. That is a direct attack onto their business. That's a direct attack onto their character and how they practice law. If a person from the public Googled their names, then presumably this Telegram thread would come up, and a potential client might not want to hire them. So then defendant Wood goes on to repost the press release that this court found just to be disparaging on its face again. So here we have another example of willful violation already on notice of what the court considers disparaging and what it does not consider disparaging. And he completely ignores that. He even admits that this is the press release I issued after, again, frivolous lawsuit was filed against me by the three lawyers. He goes on to say, I was able to issue the statement before the three lawyers got a court to unlawfully enjoin my right to publicly respond. And so in the very next post, he reposts this press release that he sent out that occurred immediately prior to the injunction being entered. Part of this court's order, the judge looked at this specific statement and said that there are parts of this that's disparaging on its face, which is why the court issued the injunction order to begin with. Some of the statements that he says in this press release that he republishes, which makes it another violation, again, filing a frivolous and unnecessary lawsuit. now in a shakedown effort to coerce me. Shakedown effort is quoted in the injunction order. He goes on to say, I will not succumb to litigation intended to extort money from me. And then again, frivolous claims and false accusations. So this is again, something that defendant Wood knew that this court said was not okay in its injunction order. And he decided, I don't care. I'm just going to do it anyways. I'm going to repost what I've already been told I'm not allowed to say. So then in this May 10th, 2021 message, he says, he calls each plaintiff out by name, and he goes on to say, I already know much of what I will find out about each of them. Every lie will be revealed. Again, casting my clients in a negative light. This is saying that there are lies about them that need to be revealed immediately after saying that this lawsuit was frivolous. So here he goes on, after posting the litigation hold letter to Brian Cave, he then goes a step further and says, I'm going to post a subpoena that I issued to Brian Cave, which is Plaintiff Wade's former law firm. In the post immediately prior to this, he again says this phrase, every lie will be revealed. It is a common phrase that he uses throughout disparaging plaintiffs. So then he takes it a step further and says, okay, not only am I going to share things that are disparaging, I'm going to now call them extortionists specifically again and say they're extortionist lawyers. They tried to extort me. Now, public, please go file bar complaints against them. You can file a bar complaint against anybody you want. And he even goes as far as saying the plaintiff should be disbarred. These, again, are statements that defendants were already on notice of as being disparaging, and he just decides he's going to post it anyways. And here we go. We're back to exactly where I said we were going to end up. May 12th of 2021, he comes back and says, just wait until Nicole Wade's HR file from Brian Cave and Powell Goldstein is made public. You will learn the truth about why she's falsely attacking me. She has a history of retaliating against others. And then there's some more that where he calls into her, he makes an allegation about her mental health, and then he goes on to say every lie will be revealed. So that's why this litigation hold letter of preserving evidence to Brian Cave is relevant, because he comes back to even reference it and disparage Plaintiff Wade. So then he goes on the very same day, and he says, again, something that is already in the injunction, that plaintiffs are seeking more money than they deserve. That's a direct violation of this court's order. He's saying that they wanted more money than they deserved in 2020. And again, they filed a frivolous fraud lawsuit against me. Direct violation of this court's order. So in this May 17th, just 5 days later, he decides to call defendant Grunberg a communist. And he even alleges that defendant Grunberg is trying to smear him due to some political agenda by exercising his right to bring this lawsuit. So then he goes on, and again, referencing the false fraud claims filed against him, which is in direct violation of this court's order. He goes on and says that to summarize the post, he's accusing defendant Grunberg of being a racist and an evil person due to some, I'm not going to say the absurd and vile anti-Semitic comments that were said in this post.
Speak up, just say objection.
Objection. And it may be that it goes to the weight. She's misreading this. I was accused of being a racist. I didn't make that accusation against Jonathan Grunberg. If you read it, you'll see it.
I'm getting to my point. He goes on to say, quote, someone falsely accusing me of being anti-Semitic or racist is evil, end quote.
I didn't disparage Jonathan Grunberg by calling him a racist.
All right.
So it's the same problem I have with many of these. And I'm going to go on the stand and go through each one. So you'll be able to separate the wheat from the chaff, I think.
Then we'll wait until that moment.
Okay.
Please continue.
Okay, so then on the very same day, he even calls out the motion for contempt that the plaintiffs filed and says that he knew it was coming. Again, this is direct evidence of his willful violation of the injunction order. So this isn't some innocent, I didn't know what I was and was not allowed to say. He even says, I knew they would file a motion for contempt against me when I finally decided to speak out and defend myself. And then as has occurred, he even threatens that, he even states that it could take years to resolve this litigation. And he's done exactly what he said he was going to do in this post. So again, he calls out, subsequently on the very same day, he calls out defendant Wilson and says that he can't hide from the truth. Truth always catches up with you. Again, casting defendant Wilson in a negative light, saying that there is something that is not truthful about what defendant Wilson is saying. So then when we filed our supplemental brief and the supplemental motion on May 19th, 2021, defendant Wood again decided to take himself to Telegram and talk about the supplemental motion for contempt that we filed. And what's ironic about this post is that defendant Wood takes issue with us bringing up his responses from his followers that have, made threats of gang rape against my female client. But he even goes on to call it out and recognize, he says that they're also really upset because some members of the public have lawfully informed them of their dislike for their frivolous fraud case. So he knows what his followers are doing. So then we go later on in the very same day on May 9th. This is where he calls the plaintiffs out for committing criminal extortion. He phrases it in a hypothetical, and later on we'll see in the next couple of slides. And later on, we'll see in the next couple of slides where he actually names the plaintiffs by name. And so he's talking about if person A claims that they owe you $600,000 on a contract, you say that you cannot pay unless certain legal rights and ethical conditions are met. Person A then threatens to file a salacious and, here we go again, frivolous fraud claim that falsely smears you in addition to a breach of contract claim, unless you immediately pay person A $1.2 million. Does that sound like criminal extortion to you? And so this post right here, these two posts came immediately thereafter, with less than an hour later, where he goes on to talk about even more criminal extortion follow-ups about what he considers to be criminal extortion. And then he calls out all three plaintiffs and posts the letter that was sent as the demand in this case. So here on the very same day again, he urges his public followers and, quote, concerned citizens, end quote, about filing bar complaints against anyone that they believe, any lawyers that they believe violated the disciplinary rules or engaged in possible criminal conduct. And he even calls out such as attempted extortion. And then he even goes a step further and says, here's the link as a public service. Here's how you file a bar complaints. By the way, the plaintiffs are all Georgia lawyers. So as I alluded to earlier, there are countless of examples, and I don't want to take up the court's entire night and go into dinner time or anything like that. So from the time that we filed our supplemental motion, as I stated earlier, there are at least 21 attempts from 21 violations from a very small time period where he repeats these frivolous fraud allegations. There are also a lot of others where he knowingly violates the same things: shakedown effort, criminal extortion, suing him for money that they did not earn, those sorts of things. But most recently, kind of just jumping ahead so that we can kind of streamline this hearing, he accuses the plaintiffs of lying in their depositions in an unrelated federal lawsuits. Immediately prior to this telegram, he posts screenshots of what he considers, quote, text messages from each of the plaintiffs. So when he posts defendant Grunberg's and he posted plaintiff Grunberg's, then plaintiff Wade's, and then plaintiff Wilson's messages to him. And he even goes on to say, immediately thereafter, do they know about perjury and its potential penalties? So again, on this very same day, immediately thereafter, he goes a step further and references the depositions that he took in this unrelated case of the plaintiffs. And he accused them of being actors in their depositions and goes on to say, who do these people think they're fooling? They're not fooling me. Are they fooling you? They are April Fools. And so this is just one example of defendant Wood reposting these responses from his followers, showing that he knows exactly what his followers are doing. He reposts this one in direct response to the prior messages we just went through that says the most important one is they're not fooling God. They need to come clean to him, capital H, assuming that means God, firstly, and then to you, Lynn. So then a couple of days later, defendant Wood decides he's not done violating this court's injunction order, even though the court was already aware of this most recent disparagement at this point. He decides he's going to call the plaintiffs out for fixing a jury in a trial that they were counsel of record for. I don't know about you, but having somebody attack my credibility as an attorney and my ability to practice law goes to the heart of who I am as a person. And so this is, again, casting them in such a negative light, accusing them of fixing the jury. He even says, sadly and tragically, ask my former law colleagues. And so these are just some of the examples of these willful contempt violations. So what does that leave us with? We already know that there's an injunction order. We've gone through numerous direct violations and willful violations. What that leaves us with is what kind of remedies we have here. So as your honor knows, there are different types of contempt remedies. The criminal contempt remedies, the OCGA 1568 subsection 5.
Let's skip forward through that part and tell me what you're recommending.
Okay, your honor, we are recommending, we went through the motion for contempt and the supplemental brief and the affidavit. And what we did was we noted every single willful violation of something that this court directly enumerated in the injunction. That consists of statements that this case is frivolous, or that the counts are frivolous, that they extorted him, a shakedown effort, or they're seeking money that they did not deserve. So those 4 different categories, when we go through what's in the record right now, there are 45 violations of those. There, as I alluded to earlier, there are a lot more of those that has occurred that's not in the record, and we can supplement it. But what we're asking for is the maximum $1,000 fine per violation for criminal contempt. And then we also are asking for a civil contempt remedy to deter future violations of $15,000 per violation. And as your honor knows, that there is no statutory limitations on the civil contempt prospective violations to deter his conduct. We're also seeking our attorney's fees under 91514 A and B. And my partner, Andrew Beal, is prepared to testify as to our attorney's fees, the amount and the reasonableness related to having to bring the contempt motion, sorry.
All right.
If you would like us to do that now, or.
All right. Well, I think that Mr. Wood or the defense would have the ability, I guess I'm going to treat that as more of like an overview opening statement. And so if the defense wants to respond, that being said, I think we still need to get to the heart of the matter. So I'll turn it over to the defense.
Okay, thank you, Your Honor.
Your Honor, real briefly, we filed a motion. We filed a response to the motions that were filed 4 days ago. And I don't think it's come up on your system yet. So if it's okay, I'll just give your honor a copy.
That's fine. Have you already emailed a copy or provided that to the defense?
No, we just filed it
Just
this
now?
morning.
All right. Well, I mean, we'll cover it in closing or argument, but
Thank you, Your Honor.
all right, Mr. Wood.
Thank you, Your Honor. May I proceed?
Yes.
Got to figure out how to get to the mic. Good afternoon. If I might take a detour for a second, I'd like to introduce the court to a new member of the Georgia Bar, John Exum. John passed the bar and he was sworn in yesterday, and I think I'm going to technically be his first client, but he's going to be a real positive force for the bar, and I want to introduce him to the court. As I understand it, this is the time to give the court some brief overview by opening of what the evidence will show. So I'll try to be brief because I'm going to be a lot of part of the evidence. What you heard from opposing counsel is what I call cherry picking. It's always important to put things in context. Here's what, from an overview standpoint, will be undisputed. This lawsuit was filed in August of 2020. And it was filed in violation of a written agreement. That'll be part of the motion to dismiss. I was represented at the time by Joey Burby and Chris Marquardt of Alston and Bird. And they proceeded to handle the case for me. I was not representing myself. When the lawsuit was filed, the allegations were so personal and so heinous against me and totally irrelevant, as the judge found, salacious, impertinent, and irrelevant to the issue of breach of contract or even the issue of alleged fraud in the inducement, which is part of our motion to dismiss coming up that should be dismissed because you can't pursue both and they've elected to proceed under contract. So I issued, when I was contacted by the Fulton Daily Report, I prepared, with the assistance of Joey Burby and Chris Marquardt, a public statement that I released to the Fulton Daily Report. After that, I didn't say a word. Joey and Chris were my lawyers. I was not representing myself. They may have a different approach to litigating cases than I have over the course of my career. But the next thing I know is the Georgia Bar opens up a massive investigation of me in December of 2020, based in part on the allegations of this complaint they filed against me. Then Joey and Chris withdrew from the case. I couldn't afford them. And I started representing myself, which I had a right to do. While Joey and Chris may not litigate for their clients in the court of public opinion, check my record. Since 1996, when I represented Richard Jewell, I have repeatedly in high-profile cases, not only litigated in the court of law, but I have litigated in the court of public opinion. And the United States Supreme Court in Gentile versus the State Bar of Nevada made clear an attorney's duties do not begin inside the courtroom door. He or she cannot ignore the practical implications of a legal proceeding for the client. Just as an attorney may recommend a plea bargain or civil settlement to avoid the adverse consequences of a possible loss after trial, so too an attorney may take reasonable steps to defend a client's reputation and reduce the adverse consequences of indictment, especially in the face of a prosecution deemed unjust or commenced with improper motives. And the rationale for that is pretty clear in the court.
I'm going to object, Your Honor. Essentially, Mr. Wood is attacking the validity of the injunction, and the law is clear.
I understand your argument, Mr. Beal. I want to let him finish his opening and then get into that and see if we can narrow the scope of the hearing.
Thank you, Your Honor.
In Gentile, the Supreme Court went on to say, to the extent that the press and public rely upon attorneys for information because attorneys are well informed, this may prove the value to the public of speech by members of the bar. If the dangers of their speech arise from its persuasiveness, from their ability to explain judicial proceedings, or from the likelihood the speech will be believed, these are not the sort of dangers that can validate restrictions. The First Amendment does not permit suppression of speech because of its power to command assent. So when I had to take over the case for myself, at the end of, I had to look for the specific date, end of April, beginning of May, I was the only lawyer on the pleadings. I was the only lawyer representing myself. Then in that time period, based on their complaint and the heinous, salacious, redundant, impertinent, and irrelevant statements they made against me, at a time when I was at the request of certain citizens in South Carolina, my new home at the time, I was campaigning for chair of the South Carolina Republican Party. And the opposition, Drew McKissick, went full bore against me, attacking me based on their allegations and their complaint. I made the decision as a lawyer for myself that I had a duty, and it's not a right, it is a duty according to the United States Supreme Court. I had a duty to advocate for myself in the court of public opinion. And I did. And if you'll look at the dates of these telegram messages, you're going to see that they're really coming in May. It's exactly the time frame that I was once again under attack. First, locally in my home in Atlanta, Fulton Daily Report. I understand their sensitivity they claim about their reputations. They accused me of blasphemy. They told the people in Atlanta, in the country, and around the world that I thought I was Almighty God. That would be blasphemy. What could be worse? And they took that out of context. If you look at what I said, you'll understand it. They accused me of being a fraud. Don't say anything about a frivolous lawsuit. You're a fraud. You can't respond. They accused me of assault. There are two sides to every story. I couldn't tell mine. The heinous accusations they made against me, totally irrelevant to a breach of contract or even a fraud in the inducement case when they knew everything they claimed was fraud. It was known to them, although they had waived fraud. They had released it in the agreement, and the covenant not to sue was only, they could only sue for enforcement of the contract, but they went much further. If the courts had done what I believe should have been done, if they had granted the motion to strike the impertinent, salacious, redundant material from the complaint, which the court found, and had granted my motion to dismiss the fraud case, which I believe, and Mr. McMurtry, a new defendant, says the same thing. I've been saying the law is clear. You got to elect. They've elected to proceed under the contract. If the court had timely dismissed the fraud case, I wouldn't have had anything to respond to, except a simple breach of contract case based on whether or not the law required client consent to a fee split between lawyers not of the same firm. This was a calculated, intentional effort to destroy my reputation professionally and personally. There's a link that the New York Times put up to the complaint. And then when you go to the complaint in the link, it was unfiled. How did the New York Times get a copy of their complaint when it had not been filed? I think I know. I think they do too. Andy Bill put in his motion that I was mentally ill because I claimed to talk to God, because I claimed to hear from God.
I'm going to object, Your Honor.
That's in his motion.
I'm going to object that it's
All right.
not in the motion, and we kind of need to get back to the planet.
This goes directly to what she brought up about every lie.
All right, no to Mr. Beal and Mr. Wood. Let's make your point, and we got to get to the evidence itself, all right?
I agree, Your Honor. Thank you. I worship a God that I cannot see by faith. And I talk to him. And if you read the Bible, you'll see where Jesus says, my sheep hear my voice. So I hear from him. And to have that type of accusation spread across the country and around the world, I think I had a duty to respond legally and spiritually. They complained that I was disparaging them when I said every lie will be revealed. I didn't say that. I wrote it. Jesus Christ said it. Luke 12:2. For there is nothing covered that shall not be revealed, neither hid that shall not be known. Therefore, whatsoever ye have spoken in darkness shall be heard in the light. And that which you have spoken in the ear in closets shall be proclaimed upon the housetops. They're accusing me of disparagement by posting the word of God. I know this is an attack on my reputation. I know why it's being done. I know their connections to David Hancock, a CIA operative. I know why they're trying to destroy me financially. I've lost the ability to practice law. It'll either be condoned by the court or it will not be. This is what's called death by 1,000 cuts. I try to live a Christ-like life, Your Honor. And I know that if I live a Christ-like life, they will treat me like they treated Christ. So I'll suffer the persecution here, for my reward will be in heaven. Heaven is eternal. Life on earth is a wisp of wind. I didn't want this fight. I tried to resolve this after we had some very contentious discussions in February because they were conspiring with my son to try to create a mental health evaluation by Dr. Phil McGraw. I knew what they were doing. 2 years later, I found the text message that proved it. Now, Dr. Phil's Dr. Phil. I didn't accuse them of rigging the jury. I said, I bet they knew who did. I said, who rigged the jury? And I listed several people, not them. And I said, I bet they know. When I get discovery from them, I'll find out. I don't have anything else to say about these people. I have said what I've said. I have told the truth. I responded to their lies with truth as a lawyer representing myself. I've said all I want to say. You can impose whatever penalty you want on me going forward, I don't have anything else to say about it. I said what I had to say. I felt like I said what I was compelled to say and what the Supreme Court of the United States gave me the right to say. This is a country that still has the First Amendment. And when we lose it, we've lost our country. What they did here was they made an effort to suppress my speech. They did not want me to respond to the lies and the propaganda with the truth. So they wanted the propaganda to stay there. A lie told 1,000 times is still a lie. But if you tell it enough times, people will believe it. That's why when I advocated in the court of public opinion for my clients, I didn't let the sun set on a lie. I got out and exposed it. Just like the Apostle Paul said, when you see it, reprove it. That means to expose it. That's God's law, not Lynn's. So I'm happy to go through, and I think I'm entitled to go through whatever it is that they keep giving up numbers, claiming I disparage them. But I think if I'm allowed to, and I have the right to, and they need to present them to me, I'll go through every one of them because I don't think they're disparaging. But when I call them, when I stated my opinion that they were extortionists, I said that in the first press release back when Joy Burby and Chris Marquardt were representing me. And then what did they do? They sued me for damages. So they've imposed a prior restraint on speech, claiming irreparable harm for which there was never a hearing to show irreparable harm. The judge just assumed it. But now, since that injunction, we know by their own actions that they have an adequate remedy at law. And they've exercised it. You do not restrain speech, prior restraint of speech, if there is an adequate remedy at law. And they have it. And even in their brief, they said all of his disparaging remarks were lies. Then they have an adequate remedy at law. Let them pursue that. Do not make an example out of someone that suppresses free speech by imposing a prior restraint on it. I was clear, and when I read the order to me read that the complaint, which has already gone all over the world, it was going to be the pleading. I could only respond to it in the case itself in my pleadings. And then the judge seal the pleadings going forward. Deprive me of my voice. Deprive me of my right of self-defense, not with a bullet, but the God-given right of self-defense by using the God-given right of free speech. I don't know how this case will ultimately play out. It may take years. It's been going on for 3+ years already. And we've been met with a lot of delays because we've had different judges, and some judges didn't want to hear it until the Court of Appeal. I don't even have a scheduling order. August of 2020, and here I am now in June of 2023, and there's not even a scheduling order in place. There's not even a discovery schedule in place. I haven't had a chance to take these people's depositions, which some may find funny. I don't. I've been deprived of due process of law. No hearing on the motion to seal. There wasn't a motion. No hearing on whether there was irreparable harm. There was no hearing. So right now, I've been deprived of at least 3 constitutional rights that cannot sustain. That cannot be the case in our judicial system. If it is, everybody in this courtroom is at risk. Because if they can do it to me and take away my constitutional rights of free speech, to redress grievances, to defend myself publicly in the court of public opinion, to deny me due process of law and a fair hearing on notice, they'll do it to you. If you become targeted, I have political views. I believe our country has been taken over by communism. But those are my political views. I speak about that on Telegram. I have used Telegram as the only voice I had as a lawyer for myself to advocate in the court of public opinion against the false accusations made against me. And I use Telegram primarily to share the word of God to the people who follow me. Some of them are here today. Some of them are all over the world. They write me. I just want fairness. I want my constitutional rights. I have nothing more to say to these lawyers. I love them. They got some of the things that I posted where I said, I pray for them. I do pray for them. I don't lie. There's not a lie worth telling when I know that God knows it and it violates one of his commandments. Ain't no benefit in this earth worth having that's going to send me to hell for eternity. So am I being attacked because of my conduct, or am I being attacked because of my faith? Apostle Paul was tried 7 times, I think, unjustly. And he used every one of those trials to preach the gospel of Jesus Christ. I know where I'm hidden. And I pray for the people that don't believe in the God of the Bible, Jesus Christ. Jesus Christ is God. He is God. And anybody that attacks me for that faith, I pray for them. So I will take the stand and go through all this in detail, but I want to give you an overview of the timeline of what happened and why I had to do what I had to do. Thank you, Your Honor.
All right. Thank you, Mr. Wood. So before we get into it, I think that we could benefit from covering some of the legal points and trying to narrow the scope of what it is we're actually here for today. And one thing I will say, Mr. Wood, I agree with you on, is that it's time to move this case forward. And the court is ready when you are, and that goes to both parties. So the intent was, after the motions to dismiss that have previously been filed are ripe to be heard, which we've already set for hearing at the end of this month. We're going to have that hearing. We're going to have a ruling, and then we're going to put in a scheduling order with the 6-month discovery timeline, and we're going to move it forward. But in the meantime, this has been pending for a while, and it looked like it wasn't over, because since our status conference, we received notice of the plaintiffs obviously highlighted some posts on April 26th. And giving you every benefit of the doubt, that is after the Court of Appeals opinion comes out. So that's what I want to try and talk about, and see, let's focus just on one of these posts, and let's see how we would apply the law of this injunction. You may have every concern about, and obviously every right to your defense as to the merits of the case. But what I've been handed is an order of the court, not mine, but it's still one that I'm obligated to enforce if it's been violated, or else the court's authority is meaningless. So what I'm here today to do is determine if it was violated. And I read the Stardust case, and I read the case that previously came up on appeal. And correct me if I'm wrong, but the arguments about a prior restraint and the arguments of this injunction violated the First Amendment seem to have already been addressed by the Court of Appeals. And so how, as the trial court, if that's already the law of the case, what authority do I have at all, even if I wanted to go against the law that's already binding on this court, as said by the Court of Appeals? I understand maybe you didn't raise the is it the State Bar of Nevada case in the Court of Appeals, but I still think that would fall under the umbrella of the First Amendment. And so, again, the law of the case, the holding from the Court of Appeals is that your First Amendment rights weren't violated by this injunction because of you made a contractual decision to impair your First Amendment rights. So that's where I am. Tell me why I'm wrong.
You have the right on a motion for contempt to again revisit the underlying order in its validity, number one. Number two, Your Honor, the Court of Appeals assumed that I had waived my constitutional rights. That was blatantly error. I never had a hearing with where I could show that I did not knowingly waive my constitutional rights to speak out about a lawsuit that I did not know was going to be filed because they had released it and covenanted not to sue. So I never had a hearing where there was a finding as required by law that I did a knowingful waiver of my constitutional right, which I couldn't have done at the time because they didn't know they were going to do something that violated the agreement.
But there was a hearing before the injunction was issued, right? September 2020. I think there's a 100-page transcript.
Joey Burby and Chris Marquardt handled it. Whether this particular issue came up, I don't recall. I can look. But I know that no one raised gentile. Nobody at the time that this injunction was issued. I had a lawyer, then I represented myself, and I exercised the constitutional duty as a lawyer to speak out in the court of public opinion. Now, I think the two recent posts deal with jury rigging in the Musk versus Unsworth case. I did not accuse these lawyers of rigging the jury.
No, let me pause there. That's not the ones I'm referring to, but we'll get to it. We'll get to it.
If you tell me, I look at
Yeah,
it.
we'll
But
get
I
to
believe
that.
you have the inherent authority and right
All right, Mr. Beal, I know you've been
to look at the
anxious
underlying
to
order.
barge in here. Let's talk about the First Amendment issue, because as I read Stardust, it seems that he had the ability to raise this gentile case, but he didn't. And generally that,
Right.
you lose out.
Furthermore, it's Gentile, Your Honor.
Thank you.
And in the
Thank you,
Gentile
Gentile.
case, they did impose restrictions on what Gentile could say outside the courtroom. And the Chief Justice of the U.S. Supreme Court said there are limits on what a lawyer can say. And in fact, the quote from Rehnquist is a lawyer's right to free speech is extremely circumscribed in the courtroom, and in a pending case is limited outside the courtroom as well. Moreover, this court's decision dealing with lawyers' First Amendment right to solicit business and advertise have not suggested that lawyers are protected to the same extent as those engaged in other businesses. So actually, the Gentile case, which is water under the bridge at this point, does support our position. The court can impose reasonable limits on what a lawyer can say outside the courtroom. And if Mr. Woods stood here and said he can contest the validity of the injunction in a contempt hearing. But let's actually take a quick look at what Georgia law really says. However, and I'm quoting from the Stardust case, however, this argument challenges the terms of the injunction itself, and such challenges cannot be raised in a contempt proceeding. And it cites the Parlin case from 2005. And it says, and I quote, "A challenge to the validity of an injunction cannot be made in a contempt proceeding to punish the violation of the injunction where there was an opportunity for effective review of the injunction." I mean, it does everything but refer to us by name in this one. Is directly on all four with us, Your Honor. And furthermore, he was represented by Atlanta's largest law firm. He had two lawyers at the hearing. It went on for hours. And if you look at Exhibit A to our brief that we filed last night, we have attached a copy of the email before the hearing from his lawyers, the two partners at Alston and Byrd. And it says, "Dear Ms. Winters, this confirms that the parties have agreed to proceed by affidavits and not by live testimony. On behalf of the defendants, I would like to alert the court that defendants have an evidentiary issue that we'd like to raise at the start of the hearing." It goes on to describe that. It was an evidentiary hearing. As we point out in our brief, it is dishonest to tell this court that there wasn't an evidentiary hearing. There was. He offered testimony through his affidavit. It was very long, many-page affidavit, and his lawyers properly quoted to it over and over again. So he had testimony. Then he says, well, the reason I didn't give you live testimony is I had no idea what was going to be in that darn complaint. But we served him with the complaint a month beforehand. He had been served. He had the copy weeks before we filed it. Then we filed it a month later. We had the hearing. He's had every due process that you can possibly have. Then this case goes up to the Court of Appeals, and the Court of Appeals says, well, wait a minute, there could be a First Amendment question. They send it to the Supreme Court, and the Georgia Supreme Court says there's no First Amendment because it was a contractual waiver. They send it back to the Court of Appeals, who issues a 15-page decision saying there was no violation of his First Amendment rights. There was no prior restraint. He drafted this agreement. He's a lawyer. He's been practicing for 40 years, and he specializes in First Amendment work. Nobody knows a non-disparagement clause more than Mr. Wood. And in fact, it was his drafting. He created it. And then he now says, well, I've got to violate it because if I don't violate it, I can't protect myself. Well, let's see. How about he says, I'm a great lawyer. I'm going to win this case. I didn't do anything wrong. I'm going to ultimately prevail. I did only what I should have done. He could have said any of those things without violating this. How does accusing my clients of fixing the Elon Musk trial somehow protect him?
Objection. There is no evidence that I made that accusation against these lawyers.
In his deposition in the federal case, he looked me in the eye. There's a videotape of it and said, yes, I think they did it.
That's in a deposition. That is not in social media. There's a difference.
I think that's a fair point, Mr. Beal. Let's do this. I think that we need to get the record established here. What I'd like to do to focus our efforts is in review of the filings. It seems to me that there are 5 dates where the postings seem to specifically name the plaintiffs, and they would arguably be the more clear-cut and more egregious violations if that's shown by the evidence. So I'd like the parties to focus initially on May 8th, 2021, May 12th, May 17th, May 19th, and then the most recent is April 26, 2023. So those are 5 different dates.
Would you run this back?
I will. That'd be May 8th, the 12th, the 17th, the 19th. Those are all in 2021. And then April 26, 2023. My review of the file showed that those were dates when the plaintiff's specific names appeared in social media posts. And so those were the 5 that I'd like to focus on. And so with that, Mr. Beal, why don't we just go into evidence?
Okay. First of all, Your Honor, we would
take a brief break for the restroom.
Yes, sir. How much time do you need?
Well, 30 minutes would sound so bad, wouldn't it? I just need to go to the bathroom, probably about 10 minutes.
All right. And
everybody else might want
you
to
can
go
use
too.
the jury room right back here.
Okay.
All right.
And Your Honor,
Before we do that, Mr. Wood, let me just hear this.
We would rely upon the affidavits that we submitted in this case, which are evidence.
I understand. So, but for that, I think we need to have something on the record marked as exhibits and formally tendered. So that's what I think we need to get to make sure the record's clear.
Okay. So can we pull those, if we need physical documents, can we just pull them out of the affidavits?
I think that would be fine. Yeah. I mean, again, pending, if there's some evidentiary objection from the defendants, we can work through that. But unless you just want to say, since they're already part of the record, but the part of this is not part of the record. The April 26 text is not in the record right now. That was just a letter you sent to me. So what I want to make sure is that the transcript has every post we're talking about.
Yes, Your Honor. So all of the majority of them are in through the 2 affidavits. And then, okay.
But I don't think the most recent one is part of the record yet in any form.
And we can do it.
All right. So we'll make sure all that gets marked and tendered, and we can take that up after a 10-minute break. So I'll be back out here at 3:35. Thank you all.
Thank you, Ron.
May the spectators have a break too.
Oh, everyone can have a break.
Okay.
The
You
court
told
is
me to go there. I
in
didn't know if you
recess.
wanted me to go to the jury
No, we're
room
not all
alone.
just gonna sit here and look at each other.
Thank you, Judge.
All right.
I just wanted to introduce myself in person.
Nice to see you.
You too.
Okay.
Actually, I can do that one for you. Oh, hey, I'll introduce myself to you. This is Nicole. Wait. Yeah, no, my writing job. I'm just partner. We're talking on the phone, and then that's Jonathan and Michael.
So I finally put a face with a name.
I know.
I know your voice isn't so distinct.
Oh, it's always so soothing and calming.
Hey, you know what? All I'm saying is, I'm not the only one you correct your pronunciation. You corrected it. George. What do you have on there? I have this.
All right, come here.
Sorry.
What? Here, do I put? Yeah.
I just think.
I needed to put Nicole up to say.
Have we verified my affidavit? Yes, right here. There is. That's good, but it's not. Let's show you.
Hi, nice to meet you.
I have. And I'm having Michael just pull out those dates that the judge referenced so that you can have them true.
State, every state, because that's people say.
Hey, drop me. So they're like, sure. Both the Soros case and the shooter allegations, both during the pendency of the I think it's
So
important.
anytime we go on a leave.
Okay.
He said it will go to five.
Okay.
But, you know, he said, as long as he doesn't walk out that way.
Okay.
What's that? You can go. Yeah, I mean, it's fine. Just remember. I did.
Law students. Where are you in school? Okay, cool. All right.
It's pretty wild.
Yeah, you picked a big one to come in on. You should have started something simple, like a DUI or something, you know? Yeah, you're gonna be thinking it's all this exciting and then everything will be boring as hell.
It's pretty exciting. Where's the popcorn?
Yeah.
So they're really cool.
We can do it electronically.
We'll have a copy of the
Of what?
most recent stuff.
If you
I
need
kind
to-
of figured.
If you don't know how to get out.
Yeah.
You can stop it.
But I don't think it's in the brief, and this is just a legal. Do you want to have, okay,
No, it's just literally.
she's gonna print a couple copies.
Oh, I'm sorry.
I'm sorry. Sure.
Oh,
Just need to take the 12 as the original 7th grace. Yes.
thank you.
You know what I could do? I could stream it.
That's what I'm saying. You could do it electronically. And the court, just in the way if you were doing a note.
Nobody brought it. I can't believe I almost printed it out.
I can't believe it either. I'm so sorry.
No, I know, I'm not, I'm surprised we did.
This one need evidence.
I didn't mean that directed at you.
No.
Shocked, I didn't, I meant to do it and then I just didn't get there. Because I'm worried. No, I was just officers now. These are all.
Yeah, I should have lost.
And that's never been.
Dates? Yep, I'm looking up.
Okay, this is for
This is it's 25. Right. This is
This what?
May 4.
Is that one of the dates? No.
I think so.
May 8, May 12.
Oh, 8,
17,
sorry.
19. And then that's all in 21. Then he's got 1 and 4, 26, 23.
This way. May 13? No.
8 is the first one.
This is the beginning of the
This one's 17.
Where's the May 8? May 8, 2021.
Court come to order, remain seated.
Remain seated, everybody. All right, so at this point, turning to the actual evidence to be presented in this case. What do you have from the plaintiffs?
We have those, Your Honor, and if you want a physical copy of the most recent ones, we have emailed them to Ms. Sue. If she can print them, we can put physical copies in.
Or we can just submit them electronically and stream them for the court.
That's fine. Again, I just think for the purposes of the record, I'm trying to make sure that they can be referred to appropriately, that we're organized. So what would be plaintiff's exhibit 1? What would be plaintiff's exhibit 2? That sort of thing. I'm not saying we have to divide the statements all. We could still have them as a batch, but I just want to make sure if there are any objections to their tendering, we can stay coherent.
Yes, Your Honor. I just think chronologically, to make most sense, exhibit 1 will be the affidavit of Nicole Wade, which was attached to plaintiff's motion for contempt brief. And that was submitted May 14th, 2021. Exhibit 2 will be.
Let me pause you there. And so you tendered plaintiff's exhibit 1. The objection from the defense?
No. We have a copy.
All right, plaintiff's exhibit 1.
I was looking to see if we have a copy of what she's got. You got a copy of that for us?
No, it's the affidavit that was submitted with the
That's fine.
brief.
All right, so we'll go through them one by one and in a moment hear from defense whether there are objections. Let's go ahead and have you outline what your other exhibits would be.
Okay, exhibit 2 is going to be the affidavit of Nicole Wade submitted in support of plaintiff's supplemental motion for contempt that was submitted on May 19th, 2021. If I recall that date correctly, it's been a little bit since we drafted that one. And would you like me to continue? And then exhibit 3 is going to be plaintiff's May 1st, 2023. I'm so sorry, that was on me. May 1st, 2023 correspondence to the court. And that is 202 pages in its entirety. And we can stream that for the court. And then plaintiff's exhibit number 4 is going to be the May 3rd, 2023 correspondence to the court, which is 3 pages. And I believe that's going to be, oh, hang on one second, I apologize. And then I'm sorry, one more exhibit. Exhibit 5, Your Honor, is going to be a telegram post from Defendant Wood on May 3rd, 2023, that we will also submit electronically streaming for the court and for everyone to look at. And I believe that's all of our exhibits.
All right, are there any exhibits in relation to attorney's fees that you referenced, or is that all going to be by live testimony?
It's going to be one cumulative exhibit, and it's going to be by live testimony, and we have copies for everyone on that one. So I believe I'm up to number
That'd be 6.
Thank you.
All right, so I think we need to make sure that defense is clear exactly what we're referring to for each of these. So let me go back through it. Mr. Wood, were you able to locate the affidavits of Ms. Wade that they're tendering as exhibits 1 and 2?
I was, Your Honor.
And are there any objections to those 2 exhibits for the purposes of this hearing only?
No, I don't think she's a proper person to authenticate, but the post to the post, so I'm.
Well, and that's essentially, are you stipulating to their foundation is what I'm getting at.
We just need to be shown the statements.
Again, the problem is they cherry pick. They put parts of a statement up, not the whole statement. So I can't authenticate unless it's true, accurate, and correct and complete. And then I'm happy to.
Well, I think that gets to a separate evidentiary issue. So if you think they're not the entirety of the statement, I think you would have every right to introduce the remainder on your part. But the question right now, I think, would be that the ones that they have picked, are they fair and accurate depictions of what they purport to be?
Yes.
Okay. All right. So that would take care of 1 and 2. Did we CC the defendants on these other exhibits that we're proposing?
Yes, Your Honor. I sent them to Ms. Sue.
All right. And would y'all have access to your email right now to be able to look at those?
Just for the record purposes, they're just the previous correspondence that they received copies of.
To the court.
No, I understand, but I think just so when we're referring to them, we know what's what. We've got to make sure that everyone's on the same page.
And we don't have anything on attorney's fees.
Not yet. I think we're going to get to that. That would be Exhibit 6.
It's going to be hard to respond without having seen
Did that, and that's what we're trying to get through here. All right. So let me know if you see anything in your email about 3, 4, and 5.
The Exhibit 3, Your Honor, I see it. They sent it to us now, which is a May 1st, 2023 submission to the court. And then the second one is a May 3rd, 2023 3-page letter. We have them.
I think there should be 3 emails though.
Your Honor, the 5th is actually a telegram post from Defendant Wood that was from May 3rd of 2023. I can submit it to the court as a screenshot, but I was just going to pull it up so that we can show that it is the original message, but we'll do both, and I'll email that right now then.
All right, and at some point, I think it's going to be very important that you also email that to Ms. Johnson.
I will make sure you get copies of all of that.
So essentially, Mr. Reyes, just let me know if you also see what they are tendering as Plaintiff's Exhibit 5, which is this electronic telegram post, apparently.
Is that a separate email?
Yeah.
I've only received 1 email from Ms. Brown so far.
Should be coming.
It may be coming in any second.
It's in the interwebs.
Got a new email, Exhibit 5. Got it, Your Honor.
All right, so no objections to Exhibits 3, 4, and 5?
No, sir.
All right, so that leaves us with Exhibit 6, and I understand, Ms. Brown, you said that that's going to be through live testimony?
Yes, and a paper copy of a cumulative exhibit.
All right, then you can call your first witness.
Plaintiff's call, Nicole Wade, could stand.
Raise your right hand. You swear that following testimony you give the court should the whole truth to help you. State your name and spell it for the court.
Nicole Wade, NICOLEWADE.
Your Honor, may I approach the witness?
It's your witness, you don't have to ask permission.
Ms. Wade, I'm handing you what has previously been identified as Plaintiff's Exhibit 1. Can you review that and tell the court what this exhibit is?
Yes, this is the affidavit that I prepared and signed let me see the date. Sorry, there are exhibits. I'm trying to find the last page. Executed on May 13th, 2021. And it was filed with the court on May 14th, 2021.
Okay. I'm also going to hand you what's been previously identified as plaintiff's exhibit 2. Review that, please let the court know what that exhibit is.
Yes, this is the supplemental affidavit that I prepared and executed on May 19th, 2021, which was filed with the court on that same day.
Okay, and so these two affidavits that you have before you, exhibit 1 and 2. Sorry, dealing with this microphone again. Okay. The exhibits you have in front of you, exhibits 1 and 2, your affidavits, those were submitted in support of the motion for contempt and the supplemental motion for contempt. Is that correct?
Yes.
Is everything in it true and accurate to the best of your knowledge?
Yes.
Specifically in regards to the Telegram posts and responses that you enumerate throughout your affidavit, are those true and correct copies of those Telegram posts?
Yes, I believe some of them are screenshots, but yes, they are true and correct copies of what was posted on Telegram.
And those posts would be the post that defendant Wood posted on Telegram?
A lot of them are defendant Wood's posts, and then some of them are posts that other people posted on his reply to Lynn Wood channel.
Okay, and the screenshots of the Telegram messages and replies that appear throughout exhibit 1 and 2, are they complete depictions of the full message that appears on Telegram?
Yes, none of the messages from that Lynn posted were truncated in any way. They're the full messages that what Lynn posted. The messages from his followers are small, but most of them were just small posts.
Okay, and so again, just to summarize, all of that is true and correct to the best of your knowledge still to today?
Yes.
Okay, and I am going to stream the next one. And I believe you should see this in front of you. Is that correct?
Yes.
Okay. I'm showing you what's previously been identified as plaintiff's exhibit 3. And just for the court's purposes, I'm going to, and your purpose, Ms. Wade, I'm going to kind of scroll through this just so that you can see that it's a complete copy.
Ms. Brown, it seems like you're laying the foundation, but they've already been admitted. So why don't we just get to the substantive questions?
Oh, okay. I apologize, Your Honor. I thought we needed to actually get her to authenticate those.
At this point, they haven't been objected to, so they're part of the record.
Okay, perfect. Okay, so going specifically to, I believe it is exhibit 1, your first affidavit that you submitted on pages 30, 31, and 32. Can you turn to those, please?
Yes.
Okay. Your Honor, I wasn't entirely sure which post on May 8th you were referring to. Would you like me to go through all 3 of them, or would you like to?
Well, I think because defense argument is that there might be placed out of context. Let's just say the entire day is at issue.
Okay. Are you on page 30, Ms.
I am.
Okay, perfect. And on page 30,
appears one of the first message on May 8th, 2021, posted by defendant one. Is that correct?
Yes.
Okay, and can you, this is a little bit of a long telegram message. Would you like to take an opportunity to skim it real quick?
I've read it.
Okay. And can you identify where in, or sorry, strike that. Are there instances in this telegram post from May 8th, 2021, where defendant Wood references this, your complaint and this lawsuit as being a frivolous lawsuit or frivolous count?
Yes, in the second paragraph, he refers to it as the unnecessary and intentionally salacious allegations. He refers to it as being totally bogus. He says that Jonathan is a supporter of Black Lives Matter. Then he says, connect the dots, draw your own conclusions. He references the bizarre order from the Fulton court and goes on to say that the courts are corrupt and clearly saying that we're corrupt as well. He says the allegations are false. So on.
Yes, sir. You have to read.
I mean, she's reading into something that's not there. Number one, if I feel like, just like many people have said many times in this world, that courts are corrupt, that's not disparaging her, but she takes that and makes it look like I'm saying she's corrupt in this text message, and it's not in there.
I think that's something you could take up in cross.
Okay, I will. Thank you.
And if the court would like, we can have Ms. Wade read this message in its entirety.
I don't think
into the
that's
record.
necessary at all. Why
Okay,
don't we just,
I'll move on.
They speak for themselves.
Thank
So
you, Your
let's-
Honor.
If there's something additional that needs to be part of the record, let's do that.
Okay, yes, Your Honor, I'll move on. All right, going on to page 31, another post from May 8th, 2021 on defendant Wood's telegram. Is that correct?
Yes.
Okay, and can you actually just read the very first sentence into the record so that it's in full context?
This was the press release I issued after the frivolous lawsuit was filed against me by the 3 lawyers who formerly shared office space with me.
Okay, and who do you understand the 3 lawyers he's referring to in this post are?
Jonathan, Taylor, and me.
Okay, and I believe on the very next page is the actual press release that he's referring to in the telegram message on page 31. Is that correct?
Yes.
Okay, and can you turn to page 32 where he actually posts the press release, reposts the press release?
Yes.
Okay, and in this, post, does he identify you and your law partners?
Yes.
Okay, and can you kind of highlight for the court what you found to be disparaging in this post?
He says that we've engaged in a disgraceful and unprofessional effort to publicly attack him. Shakedown effort to coerce him. We manipulate and ignore the truth.
I think we're back to reading what's already in the record. And also, I think it wouldn't necessarily be relevant how she personally took it, but whether just objectively it disparages her. So again, it speaks for itself, if it does so.
And do you understand that some of the statements you just enumerated were the same statements that this court previously identified as disparaging in its injunction order?
Yes.
Okay, going over in the same exhibit 1 on page 41, I believe is a post from May 12th.
Yes.
Okay, and in this post by defendant Wood on Telegram, does he specifically name you, Jonathan Grunberg, and Taylor Wilson?
Yes.
And does he state that this lawsuit is a frivolous fraud lawsuit?
Yes.
Does he state that there was an effort to extort money from him by you, Jonathan, and Taylor?
Yes.
Does he refer to you as extortionist lawyers?
Yes.
All right. And now I believe going on to exhibit 2, which is your supplemental affidavit that's previously been submitted into evidence. On page 5, is this a telegram post by defendant Wood on May 17th, 2021?
Yes.
And in this telegram message by defendant Wood, does he again refer to this case as a false fraud case filed against him by defendant Grunberg and his quote cronies, end quote?
Yes.
And then on page 6, on the next page, I believe is another telegram post on the same date of May 17th, 2021. Shortly thereafter, by defendant Wood.
Yes.
And in this post, does he specifically identify defendant Grunberg, plaintiff Grunberg, plaintiff Wilson, and your law firm, Wade, Grunberg and Wilson?
Yes.
And okay, and going on to page 7 of exhibit 2, your supplemental affidavit from a post of the same day of May 17th, 2021. Does defendant Wood again characterize this case as a frivolous fraud case filed against him?
Yes.
And does he even specifically mention WGW frivolous fraud case?
Yes.
Okay, going on to page 10 of this exhibit 2. Is a telegram post by defendant Wood on May 19th, 2021. Do you see that?
Yes.
Okay, and in this one, does he specifically name you, Jonathan Grunberg, and Taylor Wilson by your first name?
Yes.
And does he identify your law firm, Wade, Grunberg and Wilson?
Yes.
Although he refers to it as Wade, Wilson and Grunberg. But yeah.
Yes.
Okay. And in this post, does he again say that in the frivolous fraud case, they filed against me?
Yes.
And that appears in the very next sentence after referring to you by name?
Yes, correct.
And then does he go on into the next sentence to again say their frivolous fraud case?
Yes.
On page 11, the next page, later on that day, I'm still on May 19th, 2021. Defendant Wood again posted on Telegram where he discusses criminal extortion and an attempt to extort someone from money that they owe on a contract.
Yes.
And did defendant Wood ever refer to you in disparaging a post on Telegram without naming you specifically?
Yes.
How do you know that?
Is there a post that we can see? Ronnie?
I think let's lay the foundation, or let's see what the answer is going to be about what posts we're referring to. But again, I think we're just rehashing what's already been tendered in exhibits as evidence.
I was walking through the days that you specifically identified.
No, I know, but the days
Okay.
are already in the record. So let's
Oh.
add something to them. You know?
Okay, so in this one specifically on page 11, the one that we just discussed, talking about criminal extortion, in the event that somebody owes somebody $600,000 on a contract. Is this such an instance where he did not refer to you by name?
Objection, Your Honor. She's not referred to by name. It's a hypothetical situation. So it can't be disparaging of her, so I object to it.
Understood, Mr. Wood. I think she's just stating her personal interpretation of it, and that's something you can take up on cross.
Well, within minutes, he follows up with additional posts that then result in him saying, wow, look at this written email below from Andy Beal of Buckley Beal, and proceeds to say that that's about us. And then the next day, it's actually not, the post is not in here, but the next day he had another post where he said,
We object, it's not
She's
an
saying,
evidence.
she's saying it's not in here, so she can't talk about it.
I read it when it was
Well,
posted.
Ms. Wade, come on.
Sorry.
You know better than that. If maybe it's not an exhibit yet, but if she has personal knowledge of it, she can testify about it and you can cross her on it.
But I need the exhibit to cross her.
Well, presumably this would be an exhibit she's saying you posted.
I don't know what she's talking about.
Yeah. Well, in that case, that's an avenue for cross-examination.
Okay, thank you.
So going back to what you were saying, Ms. Wade, before you were interrupted, go ahead.
The following day, he posted and said, yesterday, I posted about Nicole, Jonathan, and Taylor and how they extorted me. So he tied it up and he said that it was that the post from the day before. And in fact, he repeated the post from the day before at the time. So he linked it up the next day. I think that was on May 20th. This affidavit was filed on the 19th. So it was it was after that. So we didn't file it.
Okay, and on May 19th, he also did identify you guys by name after posting these criminal extortion, quote unquote, hypotheticals.
Yes.
And these have been submitted without objection, but just to go through them briefly, I'm going to, sorry, having technical issues. Okay, and this is from Plaintiff's Exhibit 3 from the May 1st, 2023 correspondence to the court. And let me zoom in so that you can actually see this. Okay, in this, in this Telegram post on April 26, 2023, does defendant Wood accuse you, Jonathan and Taylor, of perjury?
Yes.
Objection, Your Honor. There's nothing in there that says that.
Okay, so let's go to the post
Ms. Brown,
immediately.
he's objected. I've got a rule on it.
Oh, sorry.
So I think that's in line with your previous objections. That's her personal opinion. You'll be able to cross her on it. So understood, but overruled.
Personal interpretation.
I understand. And it's not the court's,
No, I
but that's
understand.
hers.
I just want to make sure. Thank you.
Okay.
Okay, so let's go through the posts that were posted immediately prior to the accusation of perjury. On April 26 at 16:44, defendant Wood posted a, or can you tell the court what this is that he posted on April 26 at 16:44?
He reposted a text that Jonathan had sent to him in February of 2020, along with some commentary.
And 10 minutes later, on April 26 at 16:54, what is this post by defendant Wood?
He reposted a text that I had sent him again in February 2020.
That's after.
And immediately thereafter, about, what is that, 13 minutes later at 17:08, what is this post from defendant Wood?
He reposted a text that Taylor had sent to him in February 2020.
And then less than 30 minutes later, he posted this post. Is that correct?
Yes.
And what about this post? Do you feel like it's referring to you, Jonathan and Taylor?
Because he had just posted things about us that where there were texts from us to him that were positive to him and saying how we cared about him and supported him and appreciated him. And then the commentary was that we had sued him. And then this post sort of sums it up and talks about perjury.
And later on in that evening, still on April 26th at 23:15, can you describe to the court what this post is about?
It's about the depositions that he took of Jonathan Taylor and me in the federal lawsuit.
And that was within the same day of accusing you of perjury, is that correct?
Correct.
Okay, I'm gonna show you what's been marked and submitted to the court as plaintiff's exhibit 4, which is the May 3rd, 2023 correspondence to the court. And this is a April 28th, 2023 telegram post by defendant Wood. Is that correct?
Yes.
Can you explain to me why you think that, or what makes you feel that this is disparaging and about you?
Because he's talking about who his accusation that someone fixed the jury in the Unsworth trial and says who did it, sadly and tragically, ask my children and former law colleagues. They know, and they know that I know. Then he talks about praying for everyone who engaged in this evil scheme to hurt him. And he has mentioned this before in his telegram post that he's accused us of this.
Okay.
He references us. We're the former law colleagues that he references.
Okay. And going over to plaintiff's exhibit 5.
Let me pause there. I might have missed a link. What is the alleged connection between the plaintiffs and the Musk trial? Was that their client in some way?
Ms. Wade, did you and your law partners represent Elon Musk?
No, we represented Vernon Unsworth.
Thank you for the correction.
We're working with Lynn at L. Linwood PC, and we all represented Mr. Unsworth during the Unsworth versus Musk trial.
And when was that trial?
December of 2019.
Okay, and you stated that you and your law partners you all were working with defendant Wood at his law firm, is that correct?
Yes.
And did defendant Wood attend that trial with you guys as well?
Yes.
Okay, so going to plaintiff's exhibit 5, which is a May 3rd, 2023 telegram post by defendant Wood. It's a little long, so tell me when you would like me to scroll.
Go ahead. Yes.
Okay. And does defendant Wood identify you in this post from May 3rd, 2023?
Yes, he talks about WGW, which is our law firm.
Okay. And what about this post do you find to be disparaging?
Well, he talks about the fraudulent claims, but he then goes on to talk about that that we have ties to the deep state, potentially Freemasonry, potentially child sex trafficking. It's pretty disparaging to me.
One second, Your Honor.
Okay. Thank you, Ms. Wade. You can step down and plaintiffs are.
Well, not quite yet.
Oh, yeah, sorry.
All right. I'm going to pause briefly here and inquire, what other witnesses and I know we're reserving cross, but what other witnesses would you be planning to call?
Just Andrew Beal regarding attorney's fees, Your Honor.
All right, and skipping ahead, Mr. Wood, would the defense be planning to call any witnesses? I know you mentioned yourself. You would still be planning to call yourself potentially on how this goes.
Yes, Your Honor.
Any additional witnesses besides yourself?
No, we just, the problem is we don't have a chance to analyze this attorney's fees. That's new, so.
That is new, and I think
People I
that,
might have, maybe the judge you could give me some time to look at it and then submit by affidavit any response if we have one.
I think that was the plan, was to reserve ruling. If it is necessary to rule on attorney's fees, that you'd be allowed a supplemental response on that. But I'm just trying to game out because things have been proceeding a little slower than I anticipated where we are today, and if we can still finish this today. But to that end, Mr. Wood, your witness, I'd like, if we can, to confine this to 30 minutes or less.
I can do better than that.
All right, I'll hold you to it.
Yes, that's the biggest mistake, Lord. You know this.
I know you do. You just have one more question.
I only have one more question.
I know.
John, and some questions later. Good afternoon, Nicole.
Hello there.
How are you?
Wow.
Yes,
Do
sir.
you post on Telegram?
No.
Have you ever posted on Telegram under the name Jellybug, JELLIEBUG?
It's there's an N at the beginning of it, but yes, I have
Can you speak
posted.
up just a little bit? I'm having trouble hearing.
Yes, it's NJ Ellybug. Yes, I have
Yeah.
posted on a couple of occasions.
So you've also posted on David Hancock's Correct the Record page, haven't you?
I did, yes.
And you posted after the depositions were taken of you and Taylor and Jonathan, didn't you?
Yes.
And you insulted John Exum, didn't you?
I don't recall if I did or not, possibly.
Let me read this to you. Boy Wonder has,
Objection, Your Honor. It's just gonna tie into why we're here today.
So I think it's a relevant objection, Mr. Wood.
she just said she didn't post on Telegram. Now she's saying she did. And she shows a disparagement on Telegram of John Exum. I think it's at least relevant for the court to understand. I mean, everything ought to go in two ways.
Your Honor, it's a collateral matter.
It won't take but a second to
He
read it.
doesn't have an opportunity to present additional evidence on a collateral matter.
All right, we'll keep this very, very confined. I'll let you finish this one question and we'll see where it goes.
You posted, Boy Wonder has likely done no due diligence. His skills as a legal assistant are laughable. Doubt if he will ever have any job opportunities other than scurrying around after Lynn like a little mouse. Did you write that?
That does sound like what I wrote, yes.
How'd you get to Dave Hancock's channel?
Objection, Your Honor.
I'll withdraw it and restate it.
Okay.
You know who Dave Hancock is, don't you?
I do.
It's the same objection.
So what is the relevance of Mr. Hancock?
Dave Hancock has been involved with these lawyers under their own testimony as many as 10 to 20 times. David Hancock is a CIA operative who infiltrated my property in the summer of 2020 until I kicked him off, and he has done nothing but create problems with lies and false accusations about me. And if they're in bed with Hancock, that speaks to the credibility of their accusations against me.
Well, it's not so much the accusations as it is what was posted and what was said. I don't really see their intent being relevant just to today's hearing. Maybe it is at the trial where you can go into their credibility, but today it's just, were these posts posted? And it turns out that we've got exhibits that have been stipulated to that are now tendered that say they have been. And so now I think it's going to, the only question left is, did they violate the order? And the context around them doesn't really seem all that relevant to me.
I'll move on to the next question. We'll have a chance to depose them later.
That's what a deposition would be
Yep,
for.
yep. So, Nicole, you put in a bunch of text, my Telegram posts and replies and stuff. Have you yourself ever filed a police report claiming that the Telegram post by me or someone on my reply channel was a serious harm that needed to be investigated?
Objection, Your Honor.
I think that came up in the opening about the effect of it on them.
Yeah, that damages are not what's at issue here. It is, was there a violation of the court order and what's the appropriate remedy?
I agree with you there, but I think we did kind of touch on some of these issues, so I'll give you a little leeway on this, Mr. Wood.
Thank you.
I did not file a report. I did not file a report. Is the
Police
answer to the
report.
question.
Do you know whether Jonathan Grunberg has ever filed a police report about any post on Telegram?
Not to my knowledge.
How about Taylor Wilson? To your knowledge, has Taylor Wilson ever filed a police report claiming that he had been threatened on Telegram by me or some of what they perceived to be my followers?
Not that I'm aware of.
Thank you. You are aware that at the outset of the filing of your lawsuit in September, or really August of 2020, that shortly after it was filed, that you and Jonathan and Taylor received a statutory demand from Austin and Byrd claiming that your lawsuit was frivolous. Remember that?
Then
I understand, Mr. Beal. I'm going to see where this goes.
the attorney's fees. Yes, I think we received an abusive litigation letter, although it did not contend that the lawsuit as a whole was frivolous, as I recall. It only focused on a portion of it.
Okay, well, you do recall receiving the abusive litigation letter.
Yes.
Okay. You've got a claim for attorney's fees, and I understand we have to probably get to it after this hearing on another day. Have you paid any attorney's fees?
Yes.
How much?
We went through this at my deposition. Maybe, I don't recall exactly, maybe $60,000, something like that.
Is that you, or is that a total between you and Jonathan and Taylor?
We have one engagement.
So the $60,000 is collective between the three of you.
Correct.
Your share
It
being,
it may be a little more than that. I may be wrong. I know that it's at least $60,000.
but your attorney's fee agreement in this case, if I understand it, is an hourly / contingency. In other words, Mr. Bill and his group of lawyers are going to keep up with their time. And if you get a recovery against me financially, he'll take his time out of that recovery, right?
Correct.
But if you do not get a recovery, he doesn't get paid a dime, does he?
Well, no, that's not accurate because we've already paid him.
In addition to the $60,000.
I think that there is we pay all expenses, and I think there is some minimum. I could be wrong. I don't know. I haven't looked at the engagement agreement in some time. I just know that we get the monthly bills because he is billing us on an
Right.
hourly basis.
But what you're not responsible for unless you ultimately prevail in a money damage claim against me. Isn't that the way y'all described it to me?
I think that's correct.
So you basically got a free ride.
It's not a free ride at all.
Sounds like it, but that's argumentative. Thank you very much, Nicole.
All right, any redirect?
Very brief, Your Honor.
We'll see.
Famous last words.
Now, Your Honor, I kept up with what I said. I was quick, wasn't I?
Ms. Wade, have you ever had any sort of contingency agreements as an attorney while you were working with Defendant Wood?
Yes, of course.
And very brief. Since Defendant Wood is now getting into some of the responses you received from his followers, can you just read some of these for the court that you received?
All right, Ms. Brown, was this part of the affidavit that was already tendered, or are these new ones?
It was a part of the affidavit, Your Honor, but Defendant Wood objected to me going into these because he stated that he doesn't know whether his followers posted these, and then he opened the door by bringing up whether or not Ms. Wade ever filed a police report.
He may have opened the door to maybe her personal feeling or reaction, but just to her reading them all over again. That's cumulative. It's already part of the record.
Yes.
Ms. Wade, were you ever afraid by any of these responses you received from defendant Wood's followers?
Yes.
Okay, that's it, Your Honor.
Okay, thank you.
But not so afraid as to contact law enforcement. Is that right?
No, that's not true. I didn't file a police report. I did have a contact with law enforcement about it. and
Who was
what could
that?
Be done. It was through my boyfriend. He talked to someone who works with the GBI who told him how the process would work, and we didn't file a police report at that
So
time.
you found out the process if you wanted to file a police report through your boyfriend, he's a fireman, isn't he?
And a
An EMT,
certified law,
yeah.
and also a certified law enforcement officer.
I remember that, Bobby.
Yes.
He's a good guy. Tell him I said hello. So you found working through Bobby to somebody, a friend at GBI, you found out the process for filing a police report, right?
Yes.
But you didn't file one, did you?
No, because I had done some research on some of the people who had posted some of those things, and they all lived out of state. And so we found out that there was probably not much that could be done. So we didn't file anything at that time.
So you didn't feel that they posed a danger?
We did feel that they posed danger, which is why we started sleeping with a shotgun in our bedroom. Yeah, we did think they posed a danger.
So I'm at a loss. You say you identified some of these people and you were so concerned for your physical well-being, you slept with a shotgun, which I'm sure Bobby has one.
Yes.
So he always probably sleeps with one. He's a law enforcement officer.
Didn't before this, no.
Yeah. So you want us to believe that you were so scared that you slept with a shotgun. But again, you didn't contact any law enforcement, GBI, FBI, the U.S. Marshals, or any county or city or state law enforcement officer. Is that right?
I object, Your Honor.
All right, on what grounds, Mr. Beal?
If we're going to get into this, we can show all the terroristic threats that she received as a result of his post. And then what's good for the goose, but we'll be here for a long time. And I agree with Your Honor, it's probably not relevant. But
So I think an objection could be that it was argumentative in the way it was phrased.
and that it's irrelevant.
And I think that could be there too. So I'll sustain that. And I think we, does that conclude recross here?
It does, Your Honor.
All right, thank you, Mr. Wood. Can the witness be excused?
Yes.
All right, Ms. Wade, thank you.
Thank you.
Any further witnesses from the plaintiffs?
Yes, Your Honor. The plaintiff's call, Andrew Beal.
Your Honor, I'm just prepared to state my place,
Okay.
what the fees are. This is the exhibit 6 that I presented to the other side. You
All right.
want also?
Well, I've got it. All right, this has been already previously tendered and admitted without objection. And Mr. Beal, if you could just walk through, are these expenses solely confined to preparing for today's hearing and the previous motions that you filed related to contempt?
Yes, they are, Your Honor. And I am an attorney, graduate of Duke University and University of Georgia Law School. I've been practicing for over 30 years.
Just stipulate to his qualifications.
Thank you, Your Honor. And these are my usual customary hourly rates. You'll see that there's 2 invoices, one from Buckley Beal, where I was partner for 7-8 years. And then the other chart is from my current firm, Beal, Sutherland, Berlin and Brown. And the blackouts are the parts of our representations that do not relate to the contempt hearing. The initials are for the 3 of us who are here today. We've highlighted only those sections that relate to the contempt. You'll see a couple that are not highlighted that are in there. They are to show that they are not included. Those were where we had interoffice conferences, so we did not include interoffice conferences as much as possible. We put them in there to show they happened, but we didn't include them in the computation, and that's why they're not highlighted.
So to be clear, the total amount listed on the cover page is the amount you're requesting as solely confined to this contempt hearing?
Yes, Your Honor, and it's $42,445. And that includes an estimate of 7 hours for myself, Ms. Brown, and Mr. Gossett, for work presented here today. And we've already exceeded that, but that's the amount that, and the cover page is not, that's just a summary that we created for purposes of this hearing. The others are how we actually customarily keep the record of our time to bill to the WGW.
All right, understood. And what about this issue of a contingency, or how would you address that?
Your Honor, this is the normal standard hourly rate that we charge and collect. There is a contingent hourly agreement. We've been paid over $70,000. Ms. Wade said it was 60. It was actually $72,000 in this case thus far at the beginning. And then it converted to a contingent hourly. These are all the time that we have invested in the case at our normal customary hourly rate. They have not been paid because there is a contingent element to it.
Well, I guess that's what I want to sort through. I haven't come across that before. And I don't know if the case law makes any distinction that if you are awarded attorney's fees, does it matter that this money hasn't come out of the plaintiff's pockets?
It does not, Your Honor, and we're prepared to submit a quick letter brief to Your Honor within a couple of days. It happens all the time. And in contingency fee cases, there's got to be a measure of your time. What is your time? Well, it's quantum merit. It is the value of the services rendered.
Nice.
So you count up your hours, you multiply by the normal customary hourly rate that you charge, and then you're subject to cross-examination. If somebody feels that, oh, well, it took you 5 hours to write a brief, it should have only taken you 4. That's a subjective cross-examination, but it is routine. And Georgia law supports an award of attorney's fees based on quantum merit, even when the underlying agreement was a contingency.
All right. So thank you, Mr. Beal. Anything else?
I don't think there's anything else. All right.
Let me turn it over to Mr. Wood. I know this was a proffer in his place, but Mr. Beal, as you referenced, I guess on this subject, you could be subject to questioning. So Mr. Wood, is that something you would like to elect at this time? All right, Mr. Beal, I think we have to have come to.
I haven't had time to look at it.
All right. So I guess to that effect, if he is going to be formally questioned, then we'll swear Mr. Beal in.
And raise your hand. You swear affirm testimony you give to the court, shoot the whole truth will help you.
I do.
State your name and spell for the court.
My name is Andrew Maven Beal, B-E-A-L.
Okay, if I call you Drew?
Certainly.
Thank you, Drew.
Or you could call me Andy, the way you do on
I
the
made that mistake once. I apologize. I might have repeated it by accident.
couple hundred times, actually.
Well, I thought you were Andy. You got mad at me. But anyway, that's beside the point. So Drew, what percentage of your work is done on contingency fee?
25%, about 25%, about 75% hourly.
So
It has varied over the years, but for the last 2 years, I'd say it's about 3/4 hourly and 1/4 or 1/3 contingency.
So you recognize that the general rule on a contingency fee, it's based on obtaining a recovery for the plaintiff, and the lawyer gets a contingency, 10%, 25%, 40% of the recovery. Do you recognize that?
Well, that's generally how a contingency fee works, yes.
And the client knows that if there is no recovery, the attorney is not going to charge any attorney's fees under a strict contingency fee contract. You aware of that?
Yes.
But sometimes things happen and you could get fired.
And Mr. Wood, let me pause you there because it seems like we're getting into perhaps whether a contingency fee is recoverable in a contempt action. Those are more along the lines of legal arguments,
And we can,
which you'll have every opportunity to supplement and make. It seems like